Welcome to the Dialogue by Wirepoints, connecting the dots between our economy, government, and people. And now your hosts, Ted Dabrowski and Mark Glennon.
Mark Glennon here from Wirepoints. We're going to talk today about two very interesting situations involving the First Amendment and freedom of speech here in Illinois. Two big violations in my view. But what do I know? I'm a non-practicing rusty lawyer, so I've got two experts here that have been going around the country and winning cases. We're going to talk about the new diversity, equity, and inclusion policy at the University of Illinois, which is starting to get some press attention, and the sign requirement for these supposed sales tax cuts that's mandated for gas stations and for grocery stores in Illinois. With us today are attorneys from the Hamilton Lincoln Law Institute. This is a fascinating public interest law firm, which, as I say, has been in the trenches fighting these cases and doing great work. I got a kick out of a line in the Wall Street Journal that said America could use more Ted Franks. That's one of their partners there at Hamilton Lincoln Law Institute. And amen to that. We could use more firms like this too. They do pro bono work for many plaintiffs around the country, and their cases are described on their website, Hamilton Lincoln Law Institute. So joining us today is Anna St. John and Adam Schulman. Anna, you are in New Orleans, actually, I think, and you've done a number of class action lawsuits. And tell us a little bit more about yourself and what kinds of things you've been focusing on recently.
Sure. First off, thanks so much for having us on today. It's really a pleasure to get to talk about these issues. So I've been with Hamilton Lincoln Law Institute and its predecessor, the Center for Class Action Fairness, since 2015. And during that time, we've challenged a number of abusive settlements that really, harmed class members and resulted in better settlements that saved class members money, that reduced attorney's fees and gave that money to the class members. And we've also moved recently not recently, but in the last few years, we've really increased our First Amendment work, protecting free speech and separation of powers principles. And I can talk to you about a couple of those cases that we've worked on.
Yeah, we'll go through those. And let me turn to Adam first, because you've got at least one I think is directly comparable too. Adam Schulman, where are you located actually, Adam? I didn't catch that.
I'm outside of Alexandria here in Northern Virginia. That's an interesting thing about our firm. We've got attorneys all over the United States. We've actually got one of our associates in Chicago, closer to your neck of the woods. Anna down in New Orleans. We've got an attorney down in Florida now, and one in North Carolina. And Ted, who you mentioned, is in Texas, but he shuttles between DC as well. So we're all over the place, and our cases are as well.
Yeah, and a couple of your lawyers, at least, I think, are members of the Illinois and, have experience before the Seventh Circuit, which is our federal circuit here, as I recall. So let's talk about the U of I's new diversity, equity, and inclusion situation first. We've written about it. You'll see linked with this podcast a couple of the articles that we've written in the past. We wrote about it first when it was in draft form. Good new article up on it on College Fix just Friday, which summarizes it very nicely. It essentially, in my view, mandates, let's put it bluntly, woke conduct, speech, and everything for faculty members there. If you want to get promoted, want to get tenured, you better walk the talk on diversity, equity, and inclusion, which is the nice phrase, in my view, for wokeness. And this raises First Amendment issues, because the First Amendment, first of all, it applies only to government action, and this is government action because it's a state school. But it prohibits forced speech as well, compelled speech. You're not just protected in what you can say, but you can't be forced into saying something that you don't believe in. You folks here in Illinois may be familiar with the topic from the Janus case a few years ago, where went all the way up to the Supreme Court, and the court ruled in a beautiful opinion by Justice Alito that union members don't have to be compelled to participate in the political speech or activities of their union, and that was a major victory for the free speech and the forced speech doctrine. Anna, why don't you go first and give us your take on this and tell us if there are any cases that you've been working on. I know there's one that your firm has been working on that are pertinent to this.
Sure. So, this DEI statement requirement, in my mind, has echoes of the loyalty oaths from the 1950s and 60s, where professors could be fired or never hired if they refused to denounce communism and declare loyalty to the U.S. Constitution. And the Supreme Court rejected those oaths as unconstitutional. Now here, universities have tried to get a little smarter by, leaving open the actual content of these statements. But that's really just a fig leaf, because if you look at the guidance documents, it's very clear that there's a specific viewpoint, a specific kind of woke ideology that is expected to be set forth in these statements. So, I think that there is a really strong compelled speech viewpoint discrimination issue here. And we've seen other cases where right now we've supported through an amicus brief, the Students for Fair Admissions versus Harvard University before the Supreme Court now, where cert was granted. And again, you see kind of in the academic institution environment, this focus on kind of discrimination on the basis of race, sex, other kind of characteristics that are not allowed to be used to discriminate against people under the Constitution.
Yeah, and we should point out that the University of Illinois policy requires an annual statement from all faculty members describing and summarizing their work to promote DEI. And it applies across the board. It doesn't matter if you teach archaeology or Egyptian history, you've got to go out there and advocate for diversity, equity, and inclusion. Adam, you have the same take as Anna, I assume, and maybe you can start out by telling us what else you're working on that's pertinent here. I'm interested particularly in the Greenberg case, which I'm not sure that the two of you have worked on, but let's talk about it, because it sure seems on point to me, and you won a remarkable victory in my mind, because you've essentially sued the Pennsylvania Supreme Court in a federal court and won, and it's still going on. But go ahead, Adam.
It is, and I was working on that intimately myself, and so we can share an update. As of last week, the Supreme Court has decided to appeal and to the Third Circuit. So we are actually happy about that, because we've gotten a good victory from the district court, who's made factual findings in our favor, essentially, that should help us on the appeal there. But anyway, that case is, so what happened there is Pennsylvania adopted as a regulation of its bar members, a rule that they could not. So taking a step back, about 5 years ago, the American Bar Association promulgated a model rule, what they call an anti-bias, anti-discrimination rule, but really is targeting its speech that they view as offensive, too offensive to be shared in public, might make the bar member, may bring disrepute upon the bar, things like that. And they promulgated a model rule, which has in turn been adopted by a few states, but Pennsylvania adopted that 2 years ago. And they were the largest state to have done so, at least the most populous state to have done so at the time. So we decided, one of the interesting things about that is that it's not a regulation of, even though it purports to be a regulation of the practice of law, it actually regulates lawyers who want to speak at a CLE, which is a continuing legal education seminar, about their views on the law, are covered under this supposed legal practice restriction. So we thought, maybe we can get a First Amendment advocate who gives CLEs in support of First Amendment rights and against hate speech regulations, because in it of itself, that position is deemed to be an offensive and hostile position in some quarters these days. So we hooked up with an organization out of Philadelphia that does good work, the Foundation for Individual Rights in Education, and found an attorney there who's been a dream client for us, Zach Greenberg, to sue the board members of the disciplinary board, which, like you said, is an adjunct to the Supreme Court of Pennsylvania. And we won a preliminary injunction against that iteration of the rule. They appealed that last spring, and then they dismissed it because they were rewording or trying to, essentially it was tinkering at the margins of what the text of the rule was. So they ended up dismissing their appeal, and they promulgated, without any comment from the public, a new version of the rule, which in our view is no better, potentially even more vague than the first rule. So we filed an amended complaint and went through the process again, and got a ruling on summary judgment this time that the rule is facially unconstitutional, that it discriminates against viewpoints that are disfavored, and violates the First Amendment.
Yeah, so essentially it was a sort of a DEI policy imposed on lawyers, similar to the U of I situation, in my view, but actually far less onerous. I mean, the U of I's policy, in my mind, goes far beyond what was struck down in Pennsylvania. And by the way, would that same rationale potentially apply to other bar associations or rules of conduct in other states that have rules similar to Pennsylvania's?
There are a few other states that have adopted it. So, for example, the first adopter was Vermont and New Mexico. To our knowledge, our suit was the first one that actually went ahead and challenged one of these rules. Since our suit, there's been a challenge to Connecticut's version of the rule, which is, in one sense, Connecticut's version might even be potentially worse, because that version has a carve out that's explicit for pro-diversity speech. So you can't talk about these. They list a number of protected classifications, but they carve out speech in favor of in one direction. So it's explicitly viewpoint in the rule itself.
As you would expect, we're hearing people speaking up so far, faculty members at U of I, but only anonymously. If you look at that College Fix article out on Friday, they quote some anonymously. We know that's common. I mean, I know personally know faculty members at universities who say the same thing, even liberal ones who say they're walking on pins and needles. They're afraid of their own students. They have to kowtow to the woke standards imposed on them by the university. But there's at least some faculty members who are very upset about this at the University of Illinois. Anna, tell us what kind of person, what kind of plaintiff it would have to be to bring such a lawsuit. And our listeners should understand that, generally speaking, there's a doctrine in the First Amendment that speaks to chilling First Amendment rights. That is, you don't have to actually suffer the harm before you can bring your lawsuit. Do I have that right, Anna? Or tell me what position someone would need to be in. Would they actually need to be passed up for tenure, or would that just strengthen their case, or what's the situation there?
Well, you do have that right. So to bring a court challenge, a plaintiff has to have standing, meaning that they've suffered some kind of legally recognized harm. Now, the standing requirement is looser in the First Amendment context because, as you pointed out, it's meant to protect citizens, to ensure that their speech isn't chilled, that they don't self-censor, or that they don't, aren't forced to speak a viewpoint that they disagree with. So here, the plaintiff will have to be someone who's subject to the evaluation process. So it sounds like pretty much any faculty member. Now, my understanding is that the requirement of this statement is optional until 2024 or 2025. So you would need to be someone subject to that process in that time frame when it's required. It would need to be someone who's concerned that his or her viewpoint doesn't directly follow the university's view on DEI, which it makes clear in the guidance document supports only a very limited certain kind of diversity. it's always funny to hear that the need for diversity applies, but there's only a certain kind of diversity allowed. And I think it would be helpful if it's a faculty member whose subject matter expertise is, more of a hard science. In math, there's a right or wrong answer. There's certain engineering equations that apply. So if you have a field like aerospace engineering, for example, where a wrong answer is going to get people killed in flight, there's an argument even more strongly that a faculty member's DEI statement would distract from their core academic work, and there's a much less compelling state interest.
Yeah, so it would need to be a faculty member, though. Is that correct? I mean, a taxpayer or a student, for example, that would be a stretch for them to try to bring this lawsuit. Is that right?
That's right.
Okay. Adam, you have anything to add to that? What ideal features would a faculty member have to bring a lawsuit and get your firm? I mean, you take these cases on pro bono for free. So what would really interest you in a plaintiff?
I mean, I think Anna covered it pretty well. I would want someone who views the requirement essentially as asking them to subscribe to pass a political litmus test, as it were. So both of the professors interviewed in the one anonymously, as you mentioned in the article, seem to share that. Anna made a very interesting point to me earlier when she said that the universities are trying to get smarter about it, right? Because back in the Red Scare days, you would have a university have a one-sentence oath: "I affirm that I have not been a member of the Communist Party." And now it's veiled in a more cryptic generalizations, but it's quite clear from the examples that they provide that only one view is the correct view, and you better be stating that view, or unless you don't care about being promoted.
Yeah, and boy, that comparison to loyalty oaths is really accurate. And actually, I don't think they did a very subtle job in trying to cover their tracks in the case of University of Illinois. If you read the operative document again, which we'll link with this podcast. Boy, and especially for a university to be doing this, geez, I mean, it's supposed to be a place where opinions are debated vigorously, where there's academic freedom. This lays waste to this, and the ultimate blame, of course, lies not on the trustees who approve of this, but our legislature. Why wouldn't they speak up and say, "Look, you want our academic freedom and get rid of this stuff, or you're not going to get the state support that we give," and that's another place where pressure has to be brought. That's probably not going to happen from this legislature that we have in Illinois, but I, for one, hope they get the daylight suit out of them. So we'll see how that turns out. Let's turn to the other issue going on in Illinois, which is the sign requirement that was passed along with our budget recently in Illinois. Governor Pritzker suspended, he did not cut, he suspended a scheduled gasoline tax increase that was going to go into effect on July 1. It amounts to 2.3 cents or 2.5 cents or so. Suspended that until January 1st. And the new statute requires that gas stations place a sign on their pumps that says this: as of July 1, 2022, the state of Illinois has suspended the inflation adjustment to the fuel tax for the motor fuel tax increase through December 31st. The price on this pump should reflect suspension of the tax increase. It's widely seen as election year self-promotion by the governor and by the legislature. The grocery stores also have to display a sign. The grocery tax has been suspended for a year. It's only 1% in Illinois, the state share of it. So grocery stores will have to put up a sign that says, either put it on the receipts, print it on the actual receipts, or if that's not feasible, put up a sign that says from July 2022 through July next year, the state of Illinois sales gas tax on groceries is 0%. The rationale supposedly behind these is that you don't want the retailers gouging consumers for this decrease or suspension of the tax, that is pocketing the difference and not telling the consumers about it. That seems pretty transparently shallow to me. But Anna, what do you think? This putting up a sign like this is speech. And by the way, that Greenberg case made a big point out of saying that forced conduct can amount to forced speech. That's a pretty established point, I think. So this too seems like a pretty darn good lawsuit to me. What do you think?
I think that's right. In the commercial speech context, and this might get pushed into commercial speech because it involves commercial activities, though you can also see it as political speech. But even under the lesser standard of scrutiny that would be applied, intermediate scrutiny, there has to be an important government interest that's being advanced in a narrowly tailored way that doesn't burden speech more than necessary. And here, the government's saying that it's to prevent price gouging, but there's already the possibility of a fraud lawsuit. There are already fraud laws on the book that can protect against that. And so what you instead see is that this is not a narrowly tailored way of addressing that problem. There are other less restrictive ways of addressing it through the enforcement of fraud laws. And so instead, it's more about requiring these businesses, these gas stations and grocery stores, to endorse the government view, to help incumbents get re-elected, to support the tax base. And it really is a problem for these business owners, I would think, because of information overload. They might want instead to convey messages or display signage about sales that they have, to advertise certain products that they want to sell. Consumers only have a limited attention span. And so I think that this is a real problem.
Yeah, that's valuable real estate for gas station owners. I mean, you can see it in their advertisements. They go to the extent of having live videos and commercials on there, and they're forced to give some of that away to the state under this. Adam, do you think that there's any compelling rational basis, if that's the standard for a gas station that puts this up? It seems to me, first of all, in gasoline, that's very competitive. We had fights all the time. There's notices on the radio where the cheapest gas is. If gas stations work on a margin that they have to meet, and they get pressed down, I think, to the price that's affordable for them. Same thing with grocery stores. That's a notoriously low margin business. And to think that they're going to pocket this difference in the sales tax doesn't strike me as very convincing. What do you think?
Right. I agree with you. This is a thinly railed rationale for essentially trying to pass the buck on the problems that their policy is creating as far as prices at the pump, and shift the buck onto those greedy gas stations, greedy grocery stores, instead of the inflation we're seeing in society at large. And once you look at that implicit message under the law, that's certainly not an uncontroversial statement, which is part of the test for this sort of compelled commercial speech area. And in that box, I don't think there's any way that that's going to pass muster if challenged in a court of law.
Okay, and Anna, same question on the right plaintiff here. I assume that would have to be a grocery store, a gas station owner, not a customer, taxpayer, or anything else. And here you wouldn't have any problem with sort of the ripeness of their claim, because that sign requirement is going into effect immediately. But any of them would be potential plaintiffs. Is that right?
That's right. A potential plaintiff would be a gas station owner or a grocery store owner who's subject to these sign requirements.
Adam, I did see a recent news story too that we have a trade association here in Illinois that's the Gasoline Retailers Association or something like that, and they of course are very upset about this, and their board reportedly last week authorized them to bring litigation on this. It's not clear exactly what form that would take. I'm kind of thinking, however, that a trade association would not be the right plaintiff. You'd have to actually have an owner or a grocer to do this. What do you think?
Well, that might depend on whether if members of that association are actual gas station owners, then they might have associational standing. They wouldn't get if they wouldn't get anything beyond what individual members of their group have in terms of the ability to challenge a law.
Okay, well let's hope that something materializes there and that the right plaintiffs pop up. We'd love to see you go to bat on these two things for us in Illinois. We need all the help we can get here in Illinois. So let's turn more broadly to the state of free speech in America. I'm anxious to get your general take on it. It's under assault. I mean, I thank Elon Musk for putting it on the map. This is a major topic of conversation now. Perhaps not a First Amendment issue, again, because it has to be government action. Twitter, which Elon Musk is trying to buy, is a private company. A lot of people insist that social media platforms needn't pay any attention to First Amendment standards or anything else. Do you see either of you, do you see any interesting developments there, or is the First Amendment really not going to be of any consequence when it comes to what we do about the overt censorship that is taking place on social media?
The First Amendment may not be directly applicable to private social media platforms, but I think that there needs to be a broader commitment to First Amendment principles. I'm hopeful that this conversation about Elon Musk's bid for Twitter and perhaps actual purchase of Twitter will reinvigorate First Amendment principles throughout society. I think that there's been too much kind of willingness to try to silence viewpoints that others disagree with, or that you disagree with others over, instead of being willing to debate the merits of an idea. And so we really need just a broader societal commitment to these principles.
Adam, even before Musk turned up, I kind of sense that people had enough, and courts have started to have enough, and the tide has turned a little bit in federal courts, especially in favor of free speech plaintiffs. Are you hopeful there, or have you seen signs of hope?
In terms of, you mean against non-state actors, sort of free speech type of claims?
Well, but let's both. Generally, litigation seems to have picked up. I think some other victims of wokeness have been winning their cases. Different professors and such. Generally speaking, what do you think? Is the trend in our favor?
I think generally speaking, yes. I think that if you look at, just take the Supreme Court, for example, we've got a court that's probably the most First Amendment friendly in history, at least in modern history. And notwithstanding a decision that I'm skeptical of that was issued last week in a case about signs in Texas, generally speaking, First Amendment challengers have had a good run of it, and that's trickling down into the lower courts. President Trump put some good judges on the intermediate courts who definitely respect constitutional rights, and so we're seeing some generally good results across the board there.
And in terms of non-state actors, it seems to me that this is really where the future of, frankly, free speech in America is going to be decided. How we sort out what to do with social media companies who do certainly have some legitimate need to cancel or censor some things on the internet, but have obviously been going way too far and injecting political opinion into it, to the extent, in my view, that it has altered election results. What the biggest case probably, I think, is President Trump's challenge to Twitter. They threw him off of Twitter permanently, or perhaps it was Facebook. I haven't followed this case recently, but how do you see that turning out? I mean, the First Amendment is limited to government actors, because in the old days, the public square was the place where these things got debated. The public square is now social media. So how are we going to handle that? You got any ideas? It's a hard question, and this is, this is being intensely debated by legal scholars everywhere. So it's rather unfair question, but give me your take.
Well, I mean, it's an important. I agree with you entirely. This is a cutting edge issue in the First Amendment space, and I think one thing courts need to be attentive of is when you've got a relationship behind the scenes between a public entity and a private. So, for example, there was a case out of the 10th Circuit that was very interesting. It was a 2-1 decision against a First Amendment claim last year, and it involved a controversial anti-immigration restrictivist organization that wanted to hold a conference at a private hotel within a city bounds. And there was political pressure brought to bear. I believe it was in Colorado Springs. There was political pressure brought to bear on the mayor there. The mayor ended up sending an official letter to the hotel threatening to withhold protection, i.e. police and fire protection, which I thought that was the question turned on how you interpreted will not provide support, will not provide protection. Because once they received that letter, the hotel, and I forget, it might have been a Hyatt, I'm not exactly 100% sure. The hotel canceled the conference when they received that letter, understandably, as if there was going to be some sort of a protest and counter protest, they wouldn't have police support coming to their to defend the hotel's own property. So then the organization sued the mayor, and the question was whether there was sufficient state action or whether they had sufficiently been involved in the termination. And in a 2-1 decision, the 10th Circuit said that they were not. I think that was pretty myopic to view that was just a private action. You at least when you've got an accumulation of power in some of these private corporations, you have to be very clear that the public doesn't that public bodies behind the scenes aren't working hand in hand with those organizations, with those corporations.
Look, no free speech, no democracy. It's that simple. And that's why we're so appreciative to have folks like you, lawyers like you, spending your time. I'm sure you could be making big bucks in the private sector, doing other things, but you've taken on the important mission. Kudos to you and the rest of your firm doing this. Is there anything else that we should know about those two Illinois issues, or generally that the public should know about the First Amendment that you'd want to add?
Well, I think you got it just right. Free speech is so important to our democracy, and we love what we do. We are happy to talk to anyone who finds themselves in a situation where their speech is being infringed or they're being compelled to voice a viewpoint that goes against their principles. And, we're easy to find. Our website is hlli.org.
Right. It doesn't have to be a situation where they're threatening to put you in jail. They might just be threatening to take away your license, threatening to deny a benefit to you. Anything like that, reach out to us.
Very good. The law firm is Hamilton Lincoln Law Institute. Anna St. John and Adam Schulman, thanks so much for your time, and best of luck to you in your further work. Well, that'll wrap it up for today. That's all we got. We'll talk to you next time on The Dialogue by Wire Points.